Yes, I think now we can start. So welcome everybody again to today's CF webinar with our yearly case law update today on the life sciences, chemistry, pharmaceutical side. And this Thursday, we will have a corresponding CF webinar case law update for electronics and mechanical fields. So if you're not signed up there yet, you can still do so. Yeah, with me today is my partner Arvid Burikta, whom most of you will know. He's a chemist and patent attorney at our firm, just like myself. Natalie Kirchhofer, I'm a biochemist and also partner and patent attorney at Kohaus and Florak. And together, Arvid and I do a lot of EPO opposition and appeal cases, and really enjoy doing this exercise once a year to kind of select interesting decisions that we came across throughout the year. And before we actually start with the presentation, we have a couple of housekeeping issues for the webinar. First of all, the webinar is recorded, so you do not need to take detailed notes. You will also receive a copy of the slide deck and also a link to the recording later this week or early next week. If you have questions, please post them in the Q&A function in Zoom. So you can also use the chat, but we prefer getting your questions through the Q&A tool, because then we can manage them better and also respond in writing if that is applicable to your question. Yeah, and with that, I think we can start with the actual presentation. So regarding the agenda of today's webinar, you can see it here. So first we will just briefly touch on the pending referrals. So there are two groups of referrals pending just now before the enlarged Board of Appeal, and both are relevant to chemistry and life sciences cases. And Arvid will present the first one on plausibility, and I will present the second one on entitlement to priority. And then we will go into the actual case law update. And here we selected a couple of decisions for you, on the one hand regarding procedural aspects, and on the other hand, regarding material aspects. And I think with this, we can already start with the
let's get started.
Slide. Yeah.
Let's start with the first pending referral before the enlarged Board of Appeal, that is G2 of 21. This is the plausibility referral. Now, plausibility is a referral, is a concept that was developed in the case law. It's very prominent, as most of you will know, in the life science and pharma field, and also in UK patent litigation. It's rather unknown in mechanics and other fields of technology. There is no express basis for plausibility in the EPC. It is dealt with both under Article 83, sufficiency, or under Article 56, inventive step. And really where you deal with it depends on whether the technical effect is mentioned in the claim. If the effect is indeed mentioned in the claim, you deal with it under Article 83. And if the effect is not mentioned in the claim, you deal with it under Article 56. Now, the whole aim of this concept is to avoid speculative patents. The idea behind it is that the patent proprietor should only be allowed to rely on technical effects that are plausible from the application as filed. And as most of you know, it is quite common in chemical and pharmaceutical patents to rely on post-published data to prove or support technical effects. And the concept of plausibility really puts some boundaries, some cases severe boundaries, to this. Why? Because it says only if the effect was indeed plausible from the application as filed, the patent proprietor should be allowed to rely on post-published data. This is the whole concept right behind the plausibility issue. Now, the referring board in the G221 case is the Technical Board of Appeal 3302 with Markus Müller as the chairman. The referring decision is T116 of 18. It's a decision that is very much worth reading. I think it's because it explains and summarizes the case law on this whole topic very nicely. And indeed, there are three diverging lines of case law, of previous case law. Here, we have summarized these in these three boxes. The first line of case law is the concept of ab initio plausibility. Now, this really is the strictest plausibility standard. It requires that it is plausible from the application as filed in combination with common general knowledge that the technical effect shown in the post-published data was indeed achieved at the filing date of the patent. Now, here, that's important, the patent proprietor has the burden of proof. He has the burden of proof to show that the claimed effect was indeed plausible at the filing date. And this often is not very easy. Now, the second line of case law in the middle, the box here in the middle, is the so-called ab initio implausibility standard. Now, this standard is not as strict as the first one. And under this concept, the post-published evidence can only be disregarded if the skilled person would have had significant reasons to doubt that the technical effect would have been achieved on the filing date of the patent. So it's sort of flipped around here, right? Here we have a plausibility by default situation, really. This is what we have here. The burden of proof, very important, that the effect is not plausible, is on the opponent here. And of course, this makes a very big difference in practice. In practice, it makes it a lot easier for the patent proprietor. So the second box is much more patentee friendly compared to the first box. It is to some extent similar to the Article 83 test, right? Right, where the sufficiency of a claim can only be challenged with serious doubts substantiated by variable facts. So really, this reminds one very much of the Article 3 situation, also the burden of proof with Article 83 on the opponent, very similar. So big difference for line 2 is that the onus of proof is on the opponent, really making patentees' life much easier. Now, finally, there is also a third line of case law, which really refuses the concept of plausibility altogether, arguing that there is no basis for this requirement in the EPC and considering it to be incompatible with the EPO's problem solution approach. Now, this, of course, is the most patentee-friendly line of case law. However, there are not many decisions that follow this line. Really most, right, there are only two mentioned in the referring decision. Most of the boards appear to apply the ab initio implausibility, so the box in the middle standard. Now, the case, in the case underlying the G221 referral, the 116 of 18 case, the referring board referred 3 questions to the board, to the enlarged board. You'll find the exact wording of the referral questions on this slide. I won't read them out loud to you now, but really in short words, in simpler language, the questions are as follows. The first question is, should post-file data be disregarded as evidence if this data is the only evidence for a technical effect? That's the first question. Now, second question is, if the answer to question 1 is yes, can post-file data be taken into account if there is ab initio plausibility for the effect? So this is the first box that we had before. And third question is, if the answer to 1 is yes, can post-file data be taken into account if there is ab initio implausibility for the effect? So these are the three questions. Now, this whole case has turned into a quite heated political debate. There were more than 20, there were 20 amicus briefs filed in this case, many of them from generic companies, drug companies, calling, as you can imagine, for a very strict ab initio plausibility standard. And if I said earlier that it is worth reading the underlying referral decision, this is even more true for the amicus briefs. Some of these are quite amusing, right? When we read them, it's really worth looking into them. Here on the right, there is a figure from Fresenius Kabi's amicus brief, and really claiming that loose plausibility standards lead to a claim now, invent later mentality, and comparing the scenario to tourists at the beach reserving sunbeds with towels, right? This is, as I hear, the German cliche of German tourists. Well, in any event, looking into these amicus briefs is really worth it. Now, the enlarged board issued a preliminary opinion in this case on October 13. The rapporteur in this case is Mr. Beckedorf. The preliminary opinion is somewhat vague, but it hints at that the enlarged board is inclined to follow the ab initio implausibility standard. So the middle box, right? The somewhat patentee-friendly approach. So this would be good news for patent proprietors, but as always, the devil here will be in the detail, but we'll know more soon. Oral proceedings are scheduled for November 24. So in 2 weeks from now, the hearing will be held as an in-person hearing at the EPO ESA building. The video streaming has not been confirmed yet. Apparently, they are trying to video stream this, but there are some technical difficulties. Any news will be posted on the Board of Appeal website, so anyone interested should keep an eye on the website. So I think this is probably when we talk again in about 4 weeks from now, we will have news here. It's a very interesting case to follow.
Yeah, probably the most interesting case law development in our field
yes.
this year, and much awaited especially also with regard to kind of the national courts going astray there too, right? With
Exactly.
the UK being very much focused on plausibility and revoking a lot of patents, while the same cases when dealt with before the German Federal Patent Court and also the Supreme Court here in Germany, result in completely different outcomes, because the German courts so far have not recognized a plausibility standard at all.
Yes.
Yeah.
Yeah.
And yeah, regardless of how the enlarged board will decide, it will again be interesting also to see how future courts such as the UPC and also then the corresponding national courts will decide, and whether this plausibility referral decision now will then also have an impact on the national courts to harmonize the plausibility case law across Europe a bit. Okay, with that, if there are no questions on the G2 of 21 referral, we will move on to the next referral. I speak of it in the singular because it actually has 2 G numbers, but it's actually one referral to related cases which have a joint referral now pending. And this regards formal priority, an issue that has been very actively debated and also the subject of a lot of case law at the EPO. Just to give you a little bit of backdrop for the case underlying, the facts underlying this case that is now reviewed by the enlarged Board of Appeal. You're probably all familiar with the EPO standard on formal priority, where a priority can only be validly claimed if there's an identity in the applicants of the priority application and the subsequently filed applications, or at least if it is safeguarded that successors in title of all priority applicants are on as applicants on the subsequent filing. And this transfer in chain of title needs to have been concluded within the priority year. So if there's a lack of identity between the priority and PCT applicants, then patentees have to prove to the EPO that there was a succession in title in the priority year. So an assignment concluded before the PCT filing date. And as you can imagine, in many cases, this has not been possible because these assignments were either not concluded in writing or were not identifiable anymore, especially in very old cases. Most of the cases concern cases with US provisional applications, as there, right before the America Invents Act came into force in 2013, there still was a requirement that US provisionals or first filings in the US were filed by the inventors as the applicant, whereas then the subsequent PCT applications were usually filed by their employers, the companies. And here a lot of patents were revoked. Perhaps the most prominent example was the CRISPR-Cas patent of the Broad Institute et al., right, which was revoked due to lack of formal priority and then lack of novelty due to a publication of the inventors within the priority year. Interestingly, the EPO first instance opposition divisions have developed a practice which they call the PCT joint applicants approach, where at least in cases where the US priority applicants, so the inventors, are stated on the PCT form as applicants for the US only. So that's often the case, right, that in these old US originating cases, you have the possibility on the PCT request form to indicate for the US special applicants, and then for the rest of the world, the company, that in such a situation, applying this PCT joint applicants approach, an implicit agreement is believed to have been proven by this joint filling out of the application form, leading to formal priority being safeguarded. And this has, in the meantime, also been recognized, for example, by national courts here in Germany. So a case that was handled by our firm and also successful here for an E8 of 20 and 9 of 20. In these cases, the Federal Patent Court acknowledged the joint applicants approach, so also saw an implicit agreement in this joint filling out of the application form, and also the OLG Düsseldorf, so the Düsseldorf Higher Regional Court in the Chinalcha Z2 decision, similarly recognized such an implicit agreement.
So they took the patentee-friendly
approach.
Position. Yes,
yeah,
right.
And exactly such a case is now pending before the enlarged Board of Appeal in G1 of 22 and G2 of 22. And I'll show you the referral questions on the next slide. So that's in essence referral question Roman 2. But what's also interesting is that as a primary question, the board here 3304, chaired by Gabriele Alt, also puts the question to the enlarged board of whether the EPO at all has jurisdiction to assess validity of succession in title. And this was a question that was also hotly debated in the CRISPR-Cas dispute, and they are almost led to a referral. You might remember it was a very curious situation with a multi-day hearing where on the one day the Board of Appeal in that case indicated that they were inclined to refer this question to the enlarged board, but then on the next day opened the proceedings saying that they did not see a need for a referral. Now we have this referral. And as second question, we also have the large board will look into this PCT joint applicants approach, and we're very curious to see how this will, with what decision this will end. Also here there are a lot of amicus curiae briefs filed. We also filed one on behalf of a client.
Is there any indication on the timing here?
No, but
okay.
we're checking the record, also every day here. As also here the decision is eagerly awaited, and also a lot of cases are actually stayed right now. So we also have a couple of opposition appeal cases that are stayed pending decision on these referrals, and that would also be the recommendation if you have a case that you request it to be stayed until the decision is reached here. Okay, that would be the G referrals, the two that are pending. Unfortunately, no decisions yet, but we will definitely report on them in the next case law update, or also on our blog, of course. Let's come to the actual cases that we wanted to highlight to you. This time we have a couple regarding procedural aspects, just because we felt they were interesting in the one or other way. And it's like a potpourri of different aspects. And the first one we would like to touch on concerns interventions. So you probably all know that according to Article 105 EPC, a third party may join opposition proceedings as an intervener if there are proceedings for infringement of the same patent pending. So that's why also after expiry of the 9-month opposition period, if you are sued for patent infringement and there are opposition or appeal proceedings pending, you can join. There was one case this year, so the decision, the hearing was in October 2021, but the written decision came out this year, where the question was what constitutes proceedings for infringement, which then make interventions possible. And in this case, there was a Portuguese arbitration, and that's a mandatory arbitration that the Portuguese law foresees for generics companies. And here, the intervention was deemed admissible. So this means that this term proceedings for infringement has been broadened a bit, and it's worthwhile if you have a case where it's not clear whether it's really a classic infringement proceedings, maybe an arbitration or something like that, to also try to intervene. And the next two cases concern an aspect that we already touched on last time, so a year ago, and that's one aspect that you just have to keep in mind, that according to Article 105, paragraph 2 of the EPC, an admissible intervention is treated as an opposition. And that the case law is pretty clear on that regardless of which state of the proceedings the appeal or the opposition proceedings are in, that if you join as an intervener, you have the possibility to file new attacks, new documents, your complete case, just like, and the board's treated as if it were filed within the 9 months window. So there are no late filing provisions, and the boards of appeal, the oppositions divisions, they have no legal basis for rejecting such submissions. What was unclear until recently was whether the same also applies to the reply to the intervention. So if the
patentee's reply, right.
For example, the patentee's reply to the intervention, if also their late filing provisions could kick in. And in this case, it's one of our cases, a big case that we handled last year. I mean, it's just a minor procedural aspect, but it's interesting here. What we did on behalf of the patentee was resubmit all our appeal submissions, also documents that were filed after the period set for reply to the grounds of appeal. We just resubmitted them in response to the intervention. And here the board made clear that in such a case, the board had no legal basis for not admitting documents that were filed by the patentee within the time limit set for reply to an intervention. So that means that documents, arguments, auxiliary requests that could have been considered late filed and not admitted. If you have an intervention on appeal and then refile your case in response to the intervention, this can actually help patentees to get documents, arguments, auxiliary requests, and so forth admitted into the proceedings. So this should be kept in mind for interveners, that they might also influence the case to the benefit of the patentee. The next case is one which is a bit opposite. So here, it's rather the opponent and intervener that benefits from these intervention regulations. Here, the opponent used a straw man to oppose the patent, and then later on was sued for infringement, and then intervened himself as an intervener. The parties were not, so the party behind the straw man and the opponent were not 100% identical, but definitely related. And it was implicit that there was some sort of tactical ploy there, that the straw man was on purpose commissioned with the aim to be able to later join again as an intervener, because in effect you thereby open up the possibility, right, that you're not bound to the 9-month opposition period. So if you later get sued for infringement, you again kind of have, all possibilities when joining as an intervener. And while this case T384 of 15 cited below already dealt with a similar situation and stated that the intervener and the strawman opponent cannot be the same parties, so that would be procedural abuse. In this fresh case here, T2951 of 18, the board held, and we quoted here, that it is neither vexatious nor illegitimate if the opponent and the intervener coordinate their actions within the limits of the applicable procedural framework. So that's also an interesting new aspect, speaking also for perhaps strawman oppositions. But then you should also make sure that the strawman and the later intervener are not the same party, or the party behind the strawman is not identical to the later intervener. Okay, then, this is a case that's interesting for several reasons, also material aspects, but we included it here more for this procedural issue with the third-party observation on appeal. But maybe just briefly on the first point, because we talked about plausibility, here you can see an example of how strange and diverted the plausibility case law is, depending on which board you are before. And this case here, on appeal, so the patent was maintained, the opposition rejected in first instance, but then on appeal it was revoked for lack of inventive step. And interestingly here, the technical effect was considered vis-a-vis a particular prior art document. And it was questionable whether exactly this technical effect, so the improvement over the specific comparator compounds of the prior art, was rendered plausible by the application. And here, interestingly, the board distinguished between situations where a document only became known later on through the proceedings, so was not yet known at the point of filing, and a case like the present one, where in the patent it was clear that the document, the closest prior art, had already been known because it was acknowledged in the background section of the patent. And apparently here the board applied a stricter plausibility standard to such a scenario.
And that really makes sense. Board 3301 is known, right, for its very strict appliance of the plausibility test, right? Yeah, much more than 3302.
Yeah, but the procedural interesting aspect why we included this in this section is that here in T377 of 18, after the summons for oral proceedings was issued, so which kicks off the third convergence state in terms of late filing, right? So where you really have to provide prove exceptional circumstances to get documents and so forth admitted. Here, there was the curious situation that a third-party observation was filed at this very late stage, asserting that the third party was a law firm, was supporting the appellant opponent with its arguments and also filed a further document. But here the board rejected or did not admit the third-party observation, the arguments presented in the third-party observation and the document filed with the third-party observation into the proceedings. That was a question which was open, and we also had asked ourselves before how boards would deal with such third-party observations, because of course it would be an easy way to circumvent the late filing provisions if you can simply file documents via third-party observations. But here the board stated, and we quoted it here on the slide, a third party is not an actual party to the proceedings, but then they conclude that as such it should not be accorded more favorable treatment than an actual party. So here they apply the late filing provisions to also third party.
Very interesting decision.
Yeah. Okay, this is just caught our attention. Because in the first instance we are quite often faced with opponents or adversaries pointing to this section in the guidelines, so E6 2.2.2, which provides that a patentee, if you receive a preliminary opinion from the opposition division which is favorable for the patentee, or at least in certain aspects, if then in the oral proceedings, in the first instance oral proceedings, this preliminary opinion turns, that then patentees should always be allowed to react to this and also to file new auxiliary requests, right? So the guidelines read here, amendments that are submitted by the applicant or proprietor in due course in response to objections raised by the division which depart from a previously notified opinion may not be rejected as late filed. And it turns out in the case underlying T2776 of 19, the opposition division did not act according to these guidelines, but actually rejected an auxiliary request presented at oral proceedings as late filed, despite having changed its preliminary opinion. And here the board then on appeal, right, the rejection, the first instance rejection of such requests can only be revisited in the sense that they check if the opposition division applied the right discretion and criteria in rejecting the request. But here the board then agrees with the first instance opposition division, so kind of contradicts this very clear statement in the guidelines, may not be rejected, and actually confirms that yes, such requests can be rejected in certain circumstances. And the board here held, we quoted it on the slide, the fact that the opposition division changes its view on certain technical aspects between its preliminary opinion and the opinion formed during the debate at oral proceedings, so that the opposition division's view becomes less favorable to the patentee, does not mean that the patentee automatically has the right to file a new claim request during oral proceedings. And here a factor that then also played a role was that that the objections and documentary evidence based on which the opposition division then in the oral hearing changed its opinion, this factual basis was part of the opposition proceedings all the time. So they say the change of view of the opposition division did not correspond to an unforeseeable or unknown situation for the patentee. So this again emphasizes that the boards of appeal really expect patentees to react to any and all objections raised in an opposition, also by filing defenses in forms of auxiliary requests to these objections early on, and that means in essence with the reply to the oppositions. Okay, this is a bit a convoluted slide, but we think it summarizes the situation concisely. It concerns the question, I mean, in general, whether deleting claims in existing auxiliary requests is considered an amendment of the appeal case and can therefore also be subject to an admissibility test and also then not be admitted into the proceeding for late filing. And here there is quite divergent case law already on the question if you're able to delete independent claims, right? So you could have claim 1 to the compound, right? And then claim 7 to the method of manufacture. And in former times, it was absolutely possible also in the oral proceedings to delete, for example, the compound claims and at least then retain the method claims. But here, the majority of boards of appeal sees this deletion of at least independent claims to be an amendment of the case. And this we've put out here on the right. On the other hand, there are also cases that state that the mere deletion of claims should not be regarded as an amendment to the party's appeal case because it is only a less and not a more. So you only cut down on the subject of dispute, but it's not a new subject of dispute. And actually here, perhaps there will also be a referral to the enlarged Board of Appeal soon. Actually, we had a couple of cases where either we or the adversary party invited the board to consider referring this question to the enlarged board, but so far they never did. Yeah, the case we picked here, we picked it because here the issue was even whether or not you can delete a dependent claim. So not even independent claim, but a dependent claim. In that case, T1259 of 17, these dependent claims were objected for added matter. And then late in the proceedings, I guess in the oral proceedings, the patentee then offered to delete these dependent claims and also submitted a request to this end. And here the board, after a lengthy discussion of these two divergent lines of case law, comes to the conclusion that they also follow the right box, so consider it as an amendment and then assess it under the normal admissibility criteria. So in particular, if the amendment is prima facie able to overcome the objections, and then come to the conclusion that it does not, because added matter objections remain even after deleting these dependent claims. The decision is also interesting for this very aspect that the board here really at length discusses then the added matter aspects under admissibility, which is often an issue that we see, especially in the first instance, where the opposition divisions also, when assessing prima facie admissibility, they really go into the substance of the case, and you feel as if you were already discussing yes. Added matter, novelty, and whatnot, only then to come to the conclusion 2-3 hours later that it's not admitted. There, just for your information, there's a very interesting decision that we like to cite in that regard. This is this T847 of 20, where the board actually says that in such an extreme situation where there's such an in-depth discussion of material aspects in the admissibility discussion, this can be considered an implicit admittance of the request, which makes a big difference, because right on appeal, depending on whether or not that request was rejected in the first instance or not, the board cannot revisit the material aspects, but only check on this criterion of whether the opposition division exerted the correct discretion. So in that case, deleting the dependent claim the auxiliary request was not admitted into the proceedings. We note here in the final line, T424 of 21, a decision where the opposite was the result, but also there was quite some discussion on the side of the board, whether or not to admit. They also considered it an amendment, but then allowed it as they deemed it to enhance procedural economy. So I hope this makes clear to you that, even submitting auxiliary requests concerning deletions of certain subgroups of claims really makes sense. Also makes sense to submit them already in the first instance, but definitely at the very latest with your grounds of appeal or the reply thereto, or at least announce these deletions quite specifically.
Yeah, and another trap you can easily fall into on appeal is the substantiation trap. Now there are substantiation of auxiliary requests, right? There are several recent decisions that deal with this issue. The bottom line and the lesson learned from these decisions is that for each auxiliary request filed or referred to on appeal, one really explicitly should explain for what reason they are filed, in which way they address the grounds of opposition and the decision under appeal, and why they are admissible. It's not enough to rely on the first instance substantiation. It's really important to substantiate them again when filing the grounds of appeal or the reply. Otherwise, you will risk that the auxiliary request is considered to be submitted only on the date of its substantiation. And if you do that at oral proceedings or shortly before, this will most definitely be considered late filed. Now, there are two recent decisions that we picked out here. The first is T2964 of 18, a decision of the 3302 board. Here, the patentee appellant refiled with its reply to the grounds of appeal an auxiliary request from first instance proceedings, but the patentee did not properly substantiate this request again on appeal, right? Now, the board, bottom line, the board did not admit this request due to lack of substantiation. Another recent decision is T2196 of 19, different board, 3402. Here, the patentee only referred to the substantiation of the auxiliary request in the first instance. The board found that referring to the first instance substantiation is not sufficient, and again did not admit the auxiliary request. So if you are the patentee in appeal proceedings, always remember to substantiate all carry-on auxiliary requests again with the grounds of appeal or the reply. And if you are the opponent, don't make the patentee aware of any unsubstantiated auxiliary requests, because then you would possibly give him the opportunity to remedy this defect early enough before oral proceedings.
Yeah. Although also there, I mean, it always depends. Some boards also, or there are like a number of boards which also check whether objections that you raise, are late filed. So I mean, just raising it at the oral proceedings might also be a little late, but it's a delicate issue. I think the other
hide it in the brief.
The other interesting thing about 2964 of 18, I thought, because it was that it really clarified what the fate of an auxiliary request is that was not dealt with in the decision underlying the appeal, right? So here it was a case where multiple auxiliary requests were filed in the first instance, but then the opposition division maintained the patent on the basis of a higher ranking auxiliary request. So the decision does not at all deal with admissibility of all the remaining requests. And there is always the question whether these are automatically part of the appeal proceedings. But here the board made quite clear that this sole fact that they were filed in first instance and were not actively rejected or not admitted doesn't mean that they're automatically admitted on appeal.
Right. Oh yeah, now attaching the notice of opposition. Now this, another recent T decision deals with refiling documents from the first instance proceedings, really in an attempt to carry over their content, right, into appeal proceedings. Now, this normally does not work. As you can imagine here, this is an interesting decision. Here the opponent, the appellant, at oral proceedings wanted to rely on an inventive step attack. The inventive step attack was included in the original notice of opposition, but it was only very briefly indicated in one sentence in the grounds of appeal, but nevertheless indicated, right? So there was a reference to this. Now, the notice of opposition, the whole document was annexed to the grounds of appeal. The board here in this case did not consider this inventive step attack to be properly substantiated and refused it as late filed. It held that as a general rule, references to submissions made in first instance proceedings are not taken into account, and attaching the notice of opposition to the statement of grounds of appeal was here by the board considered equivalent to such a general reference. So really take-home message here is attaching first instance briefs as exhibits to the grounds of appeal or to the reply is generally not a good idea. It is much better and much safer, really, if necessary, to copy and paste, right, substantiations from first instance briefs into the grounds of appeal.
Yeah, but even better, I mean, the reason why they don't want these references, also references to first instance submissions, is because the grounds of appeal should address the decision. The decision under appeal. So also if you do the copy and pasting and don't have a lot of time, it's really worthwhile to always, if you can think of a nexus to the decision, to refer to it, because very strict boards, are even rejecting kind of these copy and paste or mere referrals to first instance submissions. So there was one case I remember where a party quoted also in italics, really as a quote, the entire first instance submission. That's also not what they're looking for. They are looking for getting the complete case in one document and always with reference to the decision under appeal. Okay, that brings us to the final part. No worries, time has progressed. We don't have too much slides on material aspects. So this year's case law update for us, is heavily focused on these procedural aspects, just to also show you how I almost wanted to call them the new rules of procedures, but they are not as new anymore. They've now really resulted in established case law, which have kind of clearly shown the lines and procedural requirement, and also the strictness with which they are applied by most of the boards. Okay, so I think on the material side, we've picked, I think, three aspects. And the first one is sufficiency of disclosure, but with respect to first and second medical use claims, right? So first medical use claims, as most of you will be aware, are claims of the format a new compound or composition for use as a medicament. So any medical use is covered, but it's still a purpose-limited product claim. So even if the product was known, so I don't know, a compound that you used in some different technological areas, like, I don't know, a paint or whatnot, if you for the first time find out that it's useful as a medicament, so for a specific therapeutic application, you're entitled to this very broad first medical use claim, which covers any medical indications. And then the sufficiency of disclosure situation in second medical use cases. Most cases that come before the boards of appeal in pharma cases are actually second medical use cases. There's not much case law at all on first medical use claims, because the usual scenario is that if you have first medical use claims, then it's often that you have a novel compound or novel substance, and then, as a further independent claim, you have the first medical use. But T424 of 21 is a case, it's interesting also for a lot of other reasons, so definitely worth a read, especially if you're working in the antibody field, because it also nicely shows how broad antibody claims, functional claims, the EPO is willing to grant and consider sufficiently disclosed, very different to the US situation, which has really, extremely restricted the possibility to functionally claim antibodies. But this decision deals with sufficiency of disclosure of first medical use claims. And here the reason why it's a bit worth of a discussion is that for second medical use claims, the sufficiency requirement has become very, very strict. So that's why maybe I take them in the reverse order and first tell you about T317 of 20, which concerned a second medical use claim. So you see it here, it's use of an effective amount of an anti-NGF antagonist antibody in the manufacture of a medicament for improving physical function in an individual having osteoarthritis. And in such a case, the Board of Appeal, just as in other sufficiency cases, applies this criterion that the application of the opposed patent needs to render plausible and credible that the claim can be worked across its entire scope. And that means for a second medical use claim, because the medical indication is a technical feature of the claim, it means that the medical effect also is really present across the whole scope of the claim. And that includes, in this case, then also all possible subpopulations of patients. And that's why we called it the subgroup attack here, because here the opponent noted that usually patients with osteoarthritis also experience pain due to the arthritis, and that's kind of the majority of the patients. And here the patent also contained data, and it was proven that for these patients, the treatment with this anti-NGF antagonist antibody really resulted in a relief. But the argument was it resulted in a relief of pain, and then indirectly also in an amelioration of the osteoarthritis condition. But the opponent argued that for patients who do not experience pain, and apparently there is a subgroup of osteoarthritis patients that do not exhibit pain, for those it wouldn't be credible that this antibody would also work. And here the board followed it and revoked the patent for lack of sufficiency. So, and also here, if you read the decision, also late filing of requests and so forth played a role. So also there you can see that if you have a second medical use claims, the boards look very closely on sufficiency of disclosure if the opponent, I mean, the burden is on the opponent, but if the opponent raises, substantiates doubts verifiable by facts, right? That's the criterion. Then you should react by it also, if it's possible from a disclosure perspective, by restricting the scope to the actual patient group narrow claim that you actually consider to be, we call it sufficiently disclosed, but in effect, because it's a medical use claim, it's where the treatment actually was shown to work. And now looking at how strictly the sufficiency requirement is applied here with respect to whether the treatment works across the whole scope of the claim. Of course, if you would apply this to the first medical use scenario, then first medical use claims should probably never be sufficiently disclosed, because they read, right, for use as a medicament, so for any kind of medicament. And this T424 of 21 is an interesting read, because it's with a nice reasoning lays out why for first medical use claims the requirement is different and more lenient, and there for sufficiency of disclosure it's considered sufficient if you show medical utility in one indication. So very different standard depending on whether you're dealing with the first and second medical use. Okay, then we also picked one inventive step case, T1349 of 19. It concerns what we sometimes call the multi-step approach to obviousness, which has actually also kept us quite busy in the last year in several of our cases. And in essence, the story of these opponents is always that, I mean, they try to make an obviousness case based on the prior art. So classic problem solution approach combining two documents. But if they see that this doesn't bring them directly into the claim subject matter, many times we see that opponents kind of argue, well, it's obvious, or it's not inventive anyway, because even if it wasn't obvious based on particular prior art documents, kind of the routine development, for example, in pharmaceutical clinical trials, dosage finding, would then have led the skilled person to a point where the invention would have become obvious. And this kind of multi-step approach is very dangerous if the boards were to follow this, because it would really kill a great many patents that are filed, maybe based on unexpected results that were found in perhaps obvious to perform research. And this is a nice decision, really clearly laying out why this multi-step approach is wrong. It's also really worth a read for those of you who deal with formulation patents, dealing with optimized combinations of, in principle, known excipients. But in that case, inventive step was acknowledged and this multi-step approach rejected by the board. And the board here notes, we've quoted it here, that the appellant's arguments, so that was the opponent, involve a convoluted set of sequential steps conceived starting from the composition defined in claim 1, so in hindsight and working backwards in an attempt to bridge the considerable gap with the composition described in the closest prior art. Since these steps are not suggested by the prior art, they can only be taken by exercising hindsight. And in a similar way, we have been quite successful also to, when kind of showing the opposition division or the board that there were multiple possibilities and also multiple decision points along the way. All of this helps refute these multi-step arguments, but T1349 of 19 is definitely a decision that one can now cite to refute such attacks. So
like a nice format there is always like a decision tree, right? That you show how many paths there are and that it's not a one-way street situation, right? Yeah. Okay, and then the final slide for today is actually deals with polymorphs, and it was incited by actually an article we wrote this year in the IAM Life Sciences edition. It's also available on our blog. Was entitled Tips and Tricks for Patenting Polymorphs. But actually, after writing it, two further quite favorable decisions came out, and we just wanted to make you aware of them, right? So polymorphs are special crystalline forms of compounds. They play a big role in the pharmaceutical field, are often criticized by generics as evergreening patents or formulation patents. But in certain cases, you can get a patent on the polymorph form of a known compound. Although, following this decision T777 of 08, that's considered a key decision which considerably raised the bar for inventive step of polymorph patents, because in that case, the board noted that in cases where the polymorph is only an arbitrary selection from a group of equally suitable alternatives, it is not based on an inventive step. And it expressly said here that in the absence of any technical prejudice
and in the absence of an unexpected property, the mere provision of a crystalline form of a known pharmaceutical active compound cannot be regarded as involving an inventive step. So this really sounds like routine screening, try and see approaches, really difficult to argue inventive step. And this was board 3301. But now we see decisions from board 3302, so the other chemistry pharma board, raising hopes that inventive step arguments might be more persuasive and successful in the future. And these two cases are presented here. Interestingly, so that's T1667 of 15 and T325 of 16. In both cases, the closest prior art situation was that already crystalline forms, so specific polymorphs, had been developed and published. Whereas in the T777 of 08 case, the closest prior art was the amorphous form of the compound. So while in the first case, the objective technical problem was to provide a crystalline form with, of course, good properties. The objective technical problem in the two cases here of board 3302 were then specifically to provide an improved crystalline form, improved over the crystalline form already known.
More ambitious problem.
More ambitious problem, and we see that quite often now, that the inventive step chances of success really depends on how much was known in the prior art. And actually, sometimes for inventive step, it sounds counterintuitive. It's better for you if there was something known in the prior art, because then you can say, you know, the skilled person already had something that worked and it pointed him or her in a certain direction, and then it's non-obvious to go another route. While if there's nothing in the prior art, so no crystalline forms at all, the skilled person might just screen all sorts of things to find a crystalline form. Yeah, so in both these cases, I will not read them out in the interest of time here. Inventive step was acknowledged, and also in both cases, that's important, the criterion of reasonable expectation of success was applied. So distancing from kind of try and see type scenarios, and also the language that was used by board 3301 in the T777 of 08 case.
So there's new hope for polymorph and crystalline form claims, right?
We should update our blog article on that. Yeah. Okay, but I think this brings us now to the end of our seminar. We really hope that you enjoyed the seminar. If you have questions, please put them into the Q&A. Also into the chat, and we will be happy to address them. Otherwise you can also provide feedback. I think you will be redirected to a feedback form, or also you can send us personal feedback. Also, if you think certain topics should be covered in our next case law update, we're always happy to receive feedback, as otherwise this is a very one-way street situation and not so interactive. I think what remains to be said, for those of you who are not on our seminar invitation mailing list, you can sign up for that. I think the link is in the chat or also on our homepage, and then you will receive invitations, not too many, but several times a year for interesting seminars, and also in-person events here at our Düsseldorf office, which are possible again.
All right.
Yeah, I see that there are no questions. So we interpret the silence here on the question side as a good sign that everything was clear. Yes, but I think if everything is clear and you don't have any questions, then we can also close the session today. And thank you all for your interest in attending the webinar, and looking forward to hopefully seeing you also in person again sometime soon. Yeah. Have a nice evening.
All right. Have a nice evening.
Bye-bye.
Bye.